The Trustee's Guide to Dementia and Incapacity. Helping a parent or loved one who has dementia is a challenging task, to say the least. Considering and executing an estate plan for someone with diminished capacity has an added element of difficulty as well. Depending on your loved one's individual case, they may lack the legal ability to execute and sign vital estate planning documents like wills, trusts, advanced healthcare directives, powers of attorney, etc. California law distinguishes the capacity necessary to create or change a last will and testament from the mental state needed to form or modify a trust. Here we're going to talk a little bit about some of the particulars to help you navigate the tricky world of estate planning and dementia. Can someone with dementia create a trust? The short answer is yes, but with significant caveats. A trust is a legal document created by a grantor who places property into the trust for the benefit of one or more beneficiaries. The grantor is the individual who starts the trust and owns the assets before they put them into that trust and it becomes trust property. So a grantor with dementia can create a new trust, but only if they still have the legal capacity to take that action. California law outlines the capacity required for someone to create a trust in Probate Code Section 812. To create a trust, the grantor must have the ability to understand and appreciate 1, the responsibilities created by a trust, 2, the consequences of creating the trust for both the grantor, him or herself, and others, and 3, the inherent risks in trust creation, as well as the reasons to take these risks. Simply put, trust creation is a complicated endeavor, on par with any other contractual obligation that is not to be taken lightly. Therefore, California probate law requires a grantor to have sufficient mental capacity to understand the actions they're taking. Can someone with dementia change a trust? While trust creation requires a higher level of legal capacity, changing an already established trust may be less burdensome depending on what the change is. So for someone with dementia, amending a trust may only require the same showing of capacity that you need to change or create a will. In those instances, California Probate Code Section 6100.5 is going to govern that level of capacity. And under that standard, anyone 18 years or older can execute a last will and testament or modify a trust amendment as long as 1, they understand the nature of their property, 2, they know the relationship that they have with their relatives and beneficiaries, and 3, can understand the general extent of their assets and wealth. This standard is far less rigorous than what's required to create a trust. Therefore, it's always a good idea to discuss trust creation earlier when there are no questions regarding you or your loved one's legal capacity. And if there are capacity issues, in consultation with your estate planning lawyer, decide whether a will might be a better option than a trust. Does a person with dementia have legal capacity? The short answer is maybe. Dementia is not a linear disease. Often a patient will have good days and bad days. So while your loved one may be lucid and have legal capacity on Tuesday morning, their condition may not be sufficient for them to have legal standing by that weekend, or maybe even later that day. It takes an expert to not only diagnose dementia, but understand the disease's effect on your loved one's legal capacity. Talking with your parent's doctor and relying on their judgment whether there's enough capacity for significant estate planning tasks is a first step in making those determinations. How do you prove mental incapacity? If, after consulting with your loved one's doctor, you determine that they can execute a trust, proceed with caution. Having the doctor memorialize the patient's condition at the time the trust was created is going to give you evidence that you might need later to show that they knew what they were doing. Follow that same process for changing a trust or executing a will. It's crucial that the doctor not be named a beneficiary so that their diagnosis and opinions are impartial. However, if you and your parent's doctor determine that they don't have legal capacity to complete an estate planning task, you may seek legal conservatorship, which will give you an opportunity to make those decisions in their stead through the courts. If you're appointed a conservator, then you can create a trust on their behalf, again with the help of the court. This is what's often referred to as a substituted judgment in those probate court proceedings. When should a trustee contact a trust litigation attorney? A trust litigation attorney can help you navigate this process at any stage. Though we're not doctors, experienced trust lawyers will have intimate knowledge of legal capacity and what it takes to establish it or defeat it. It's always advisable in these circumstances to speak to an attorney earlier in the process especially if you have concerns about dementia. You'll also need to speak to a trust litigation attorney anytime you believe your parent or loved one has created a trust that doesn't reflect what they actually wanted. Unfortunately, abuse, elder abuse specifically, and coercion of dementia patients during estate planning happens all the time. And all too often it takes a lawsuit to unwind a manipulation or a fraudulent document. Have questions? Give us a call, shoot us an email anytime. At RMO, we protect people like you every day. Thanks for watching.